So these two are sworn enemies. But at the same time, the constitutional makers in India had a balance between these two core fundamental values, right to equality and right to freedom. Article 14 is there, Article 19 is there. So Article 21, life and personal liberty. So in order to achieve Article 21, these two are to be there. That's why in Maneka Gandhi versus Union of India, the other day also, after having emergency experience, in India we have post-emergency liberal policy where Supreme Court also came from its own shackles. So until Maneka Gandhi versus Union of India in 1978, where the minority judgment of H.R. Khanna became the majority judgment, where right to life and personal liberty were given in a broader perception, where the Supreme Court of India, in its activistic role, until that particular point of time, 1978, Maneka Court, Supreme Court was considered as sitting in ivory tower, without considering the social value, social repercussions of their judgments. Supreme Court was simply attached to the locus standi principle. Locus standi principle was, when a person comes to the court, court has to see two things: whether that person has a right to stand before the court. When can a person has the right to stand before the court? When the person's right is infringed. To have to enforce his right, he will come to the court. The first question the court has to answer is whether the person has locus standi or not. The second question is to be answered is whether the court has jurisdiction or not. If it has no jurisdiction, court has no power. So unless after answering these two questions, the court can permit the litigant to continue the litigation. But after Maneka Gandhi case, the Supreme Court of India, regarding the enforcement of fundamental rights, liberalized this locus standi. Any public spirited person can come to the court, particularly writ courts, high courts and Supreme Court, in order to have public interest litigation. Initially, there was a lot of bitter opposition. Justice Sedayatullah, Justice Ullafur were opposing this particular policy. But in 1982, by transfer of judges case, S.P. Gupta versus Union of India, the Supreme Court of India recognized this public interest litigation process. In order to understand that justice should be delivered to the doorsteps of the people. From then onwards, even though the initial hiccups are there, particularly for some criticized it as publicity interest case, all these criticisms, the Supreme Court of India permitted the public spirited persons to file the writs on behalf of honorable justice. Corrective justice is criminal justice system. So, and another type of justice is, of course, the concept of justice was further developed by Amartya Sen. In 2007, he wrote a book after having these two books in modern concept of justice. One is John Rawls' Theory of Justice, another is Martha Nussbaum's Frontiers of Justice. Amartya Sen, well-known economist and laureate from Indian origin, he wrote Concept of Justice. For him, removal of inequality from the society is justice. So he had a beautiful example of one flute with three children. So different children have different rights over that flute. But who will be given? So one made that flute, another is an expert to sing, to utilize that particular thing for music purpose. The third one is the flute can be used to play a part. So different children have different claims over the flute. So who will be the real beneficiary of that flute. This flute example can be extended to the people living in a society like this. You go for that concept of justice, as a young law student, you should develop simultaneously to read what is justice, what is law, what is the function of law, what is the end of law. End of law is always justice. End of law is justice. We are trying to understand what is this justice. Distributive justice in the Aristotle sense, then it was transformed as social justice. Now we are talking about transformative justice through constitution, constitutional justice, transformative justice. So they want the change. Social transformation is possible through law. Then another one is corrective justice. Corrective justice means every society functions on established norms, and people are asked to follow those norms. If any particular individual deviates from the established norms, he will be corrected. All criminal legislations are called as correctional legislations, correcting the deviant behavior of the people. So the purpose of corrective justice is, criminal justice system is, correcting the deviant person and to bring him back to the mainstream. So the prison system, the penalties, all these are the process, the parts of the the criminal justice system, just to correct the deviant behavior. If correction is not possible, the ultimate capital punishment, if that existence of that human being, that person of the society is not in tune with the societal norms, he will be extinguished. So the capital punishment, death penalty is given. Even in India, even now the death penalty as a capital punishment exists. So the purpose, the corrective justice, if correction is not possible, that person will be extinguished. Court may award death penalty. So here, of course, regarding the history of death penalty is also concerned. So in Jagmohan case, in the rarest of the rarest cases only, death penalty can be imposed. Generally for the offence of murder, either life imprisonment or death penalty can be awarded. So generally life imprisonment is a rule. Imposition of death penalty is an exception. So still several countries abolished the particular death penalty, but some movements were there in India also, but still we have that capital punishment existing in our Indian criminal justice system. So that is the second part of distributive justice, what I discussed all these things. Then corrective justice, criminal justice system. In another way, justice is classified as civil justice and criminal justice. For the convenience of the functioning of the courts, some courts were identified as civil courts. Civil litigation will be entertained by the civil courts. Some courts are identified as criminal courts. So the prosecution and everything will be carried out by the criminal courts. So the function of civil court is, it has two functions. When a person comes to the civil court, I already told you whether that person has locus standi and whether that court has the jurisdiction. Then the first thing the court has to see is, so recognition of rights. When a person gave some money on promissory note to other person, if that other person did not repay, this person has a right to be recognized by the court. He will come to the court. Court can examine whether he has a right. So if that person has a right, it will be recognized by the court. The first function of the civil court is recognition of the rights. If the plaintiff has no right, court will not accept that particular litigation. So the first one is recognition of the right. The second one is enforcement of the right, execution of the right. A court will have the execution. Say for example, a decree was passed against a particular person and judgment data. A decree was passed in favor of a person, decree won. But judgment debtor has a property not in the particular jurisdiction of the court. He might have property in another court, the jurisdiction of the court. So executive court can implement that decree. So that is what is the function of a civil court. Of course, civil court, different nomenclatures were there. Ultimately, at district level, district court is civil court, then appeal to district court, from district court, high court original jurisdiction and appellate jurisdiction, civil appellate and criminal appellate, then from high court to Supreme Court. Supreme Court has original jurisdiction as well as appellate jurisdiction, civil appellate jurisdiction and criminal appellate jurisdiction. So this is regarding civil justice and criminal justice. So this is one of the classification of civil court and criminal court. Then the third way, the justice is classified as natural justice and positive justice, legal justice. Natural justice and legal justice. Legal justice, by applying the justice according to the established law. Whether that law is just or unjust, the court does not bother. So say for example regarding the implementation of right to life and personal liberty, any procedure. What is Article 21? No person shall be deprived of his life or personal liberty except the procedure established by law. The procedure is established, anybody's life or personal liberty can be taken away. So in A.K. Gopalan, the court simply looked into the procedure. When the procedure was there, then okay, Gopalan's rights were not recognized. By the time of 1978, Maneka Gandhi, procedure need not be the mere procedure. Procedure should be a just procedure, a fair procedure, a reasonable procedure. Natural justice principles are to be applied. Maneka court recognizes natural justice, whereas in 1978, post-Maneka scenario, now till today we are following the ratio of Maneka judgment. Your human right jurisprudence, your right to privacy, your all these right to environment, all these are recognized through the recognition of natural justice. Now there is a conflict between legal justice and natural justice. Natural justice is to be followed. So that is one thing. That's why when you are studying the law as a younger law student, you should know all these fundamentals of the law. So Constitution of India is the fundamental law of the land. Your entire legal system is based upon the Constitution of India. Anybody can challenge any legal procedure as violative of your Constitution of India. But fundamental rights cannot be challenged. Fundamental rights are inherent sacrosanct values. So those are attached to the human being on his birth, on her birth. So you can challenge any provision as violative of Constitution of India. But Constitution of India cannot be challenged. The reason is, it is presupposition. Like there was a discussion in Kelson's pure theory. Kelson studied the legal system in the form of hierarchy of norms, basing upon one grand norm. All your subordinate norms are based upon one grand norm, that is basic rule. In any country, grand norm is constitution of that particular country. In India, we have Constitution of India. But you can validate or invalidate the subordinate norms in the light of the grand norm. But you cannot challenge the very existence of grand norm. Grand norm is presupposition. Your Constitution of India is presupposition. Say for example, the present Constitution of India is to be replaced then there should be a referendum, a constitutional mandate, a constitutional assembly is to be reconstituted, and the existing constitutional value should be examined. All these things are there. As long as Constitution of India is there, from 1950 January 26th, that is the presupposition. Your legal system is based upon the Constitution of India. So you can challenge any law as violative of your Constitution, particularly fundamental rights or any constitutional right. So that is one thing. So that's why justice can be classified as legal justice and natural justice. In legal matters, you are being invited, you are informed, particularly the fundamental things of the legal structure. So what is law? What is the function of law? What is the end of law? If you come to the what is law, law was understood by different people in different places. And the material sources of law. Now what is law in India? It was confined to three concepts. Your custom is law. Your usage, wrong usage becomes custom. Your custom is law. Your precedent, the judicial decision is law. Your legislation is law. The modern source of law is legislation. If any point is to be there, so legislation can be brought. These are all conveniently taken. Say for example, who gave the independence, under which enactment India got the independence? Indian Independence Act 1947 passed by British Parliament. It is a token one. Today in 2026, can British Parliament pass another legislation, thereby abolishing Indian Independence Act 1947? It is not possible. So that's why Justice Krishna Iyer says law should be a servant to the people. It should not be master of the people. So law is a tool. Legislation, judicial decision, custom, all these are tools for the human being to have to regulate their own. So here that's why the material sources of law is either custom or legislation, modern legislation. That's why you are studying in almost all these 40 subjects, you have several legislations to be studied. Go to Transfer of Property Act, one act will be there. Go to Environmental Protection Act, some 4 or 5 acts may be there. Go to, you have Indian Penal Code, one major, one substantial law, procedural law. So combination of both substantial and primary rule and secondary rule gives you what is law. Entire your legal study provides you to know what is law. Law is to be distinguished from unjust. So you have to understand the analytical capacity. You have to develop the analytical skill to understand what is just and what is unjust, so that now you can distinguish just from unjust. So just can be promoted. So here that's why even in Maneka Gandhi, law should not be any draconian law. It should be a just law, a fair law, a just law, a fair law, and a reasonable law. So you know, Immanuel Kant is a philosopher of 19th century. When there were some criticisms against the natural law philosophy, he protected natural law by creating. Previously, what was the opinion of natural law? Law was dictate of God. Law was dictate of nature. But whose God? There were some controversies, confusions. So to settle all these things, Immanuel Kant in 19th century developed pure reason. And he wrote 3 or 4 books on only reason. He spent his entire life to understand what is reason. So he simply identified law is dictate of reason. Reason includes intuition. So what is reason? That is categorical imperative. In human beings we have different impulses. He was able to classify hypothetical impulses and categorical impulses. Follow. Law is dictate of reason. So you go to Article 14. Classification should be reasonable classification. A doctrine was promoted by Supreme Court to understand what is the dynamics of equality. Reasonable classification, where there should be intelligible differentiate to classify the people. Say for example, DSNLU wants to provide some benefit to girl students. So people can be classified as girls and boys. This basis is dependent upon intelligible differentiate. That differentiate must have the nexus with the object sought to be achieved. That is what is reasonable classification developed by Supreme Court of India. Then if you come to the Article 19, you are given freedoms. Originally 7 freedoms, now after removing the right to property, we have 6 freedoms. But there were restrictions can be imposed, which can be imposed by the state. What type of restriction state can impose on your freedom? Not any type of restriction. It should be reasonable restrictions. So in order to understand Article 19, freedoms, you have to understand reasonable restrictions. In order to understand Article 14, you have to understand reasonable classification. For that, the Supreme Court further developed another doctrine, doctrine of arbitrariness. Doctrine of arbitrariness. Then, if you come to Article 21, procedure or law should not be any type of law. Law should be just law, fair law, reasonable law. Procedure should be just procedure, reasonable procedure and fair procedure. So, Immanuel Kant's law as dictate of reason still rules the world, the intellectual world, to understand the modern legal systems. So that's why friends, while studying, you are introduced to different subjects in different semesters. But ultimately, you have a comprehensive opinion, a pragmatistic approach about all these subjects to develop a comprehensive idea about the functioning of the legal system. So I already told you what is law. What is the function of law? Law is an effective agency to maintain social control. Education is an effective agency. Family is an effective agency. Religion is an effective agency. In sociology, you will learn all these things. Law is also an effective agency to maintain social control. That is the first function of law. The second function of law is an effective instrument to bring social transformation in the society. Law and social change. Prior to 1955 Hindu Marriage Act, there was polygamy among the Hindus. So monogamy was introduced under Hindu Marriage Act 1955. Family law brings you social change. Labor law brings you social change. Constitution of India is an effective instrument to bring social transformation. So, function of law is twofold. One is an effective agency of social control. Another is an effective instrument to bring social transformation. So, as a law student, you should answer these 3 questions forever. What is law? What is the function of law? What is the end of law? If you read any subject, you have to pose these 3 questions. What is the law provided in that particular subject, in that particular enactment? What is the function of that law? And what is the end of that particular law? The end of law is